Our next speaker, it's my pleasure to introduce San Francisco Assessor Joaquín Torres. Assessor Torres has a long record of supporting San Franciscans, previously at the Office of Economic Workforce Development, in his current elected position, and in many other previous roles. The library has been fortunate to collaborate with Assessor Torres and his office to promote financial empowerment and to ensure that San Francisco has an economy that serves all of our community members equitably. I attended the recent Family Wealth Conference that he organized and was amazed by the opportunities that event provided for people to connect with resources that allow them to grow and thrive. So please help me welcoming Assessor Joaquín Torres.
Thank you. How's everyone doing? All right, great. It's a bit of a long presentation with a lot of intricate information, and I believe that you all have some handouts as well. Is that right? If you like some, but we'll have the information up here, and if you sign up, we can make sure we can get this information to you as well if you don't have a paper copy to take with you. But my name is Joaquín Torres, and I'm your elected assessor recorder here in San Francisco. And some of you may be wondering why an assessor recorder would want to be part of a financial empowerment presentation. I personally believe that financial empowerment and thinking about the financial stability of San Francisco is not only connected to my work in fairly and accurately assessing all value in the city, from commercial properties to residential properties, which create over $4 billion in general fund revenue for the city, but it also means making sure that you have the information that you need in coordination with partners across San Francisco, nonprofit partners, government partners, to make sure that you have the information that you need to make strong choices about your financial future and how you can grow your wealth as you are able to, either through the assets that you hold, through home ownership, or otherwise. So I just want to say thank you all very, very much for being with us today. And basically what we'll talk about are some of the basic components surrounding property tax law, very specifically Proposition 13, and then recent changes that took place to that long-standing, those property tax laws, rules, regulations, and codes that were most recently changed during Proposition 19's passage in November of 2020. That impacted both seniors who were seeking to transfer their properties with lower or maintaining lower property assessment values, which impacts lower property tax obligations, and also the impacts that have changed regarding intergenerational base year value transfers when a property, when a family, a parent, or a grandparent wants to transfer a property from one generation to the next. And that element is a bit more controversial. And so we want to make sure that people are aware about the details. The most important piece of information that I want you to walk away with is I hope that something that I say today in the presentation, no one's expecting you to absorb all of it, but what I want you to take away is that if you have any questions whatsoever regarding your property assessment, your property values, or the rules that govern what happens when you change hands in a property, make sure to reach out to our office to ask those first level questions, the first point of contact. And then always remember that you should be speaking with an estate planning attorney or other legal advisor, because everyone's situation is unique. And there are many nonprofit partners in the legal field that we can help refer you to help you have those conversations either at free or at very, very low cost, depending on your income level. Again, remember the most important thing I want you to walk away with today, beyond some of the information that you hold here, is making sure that you know that our office, at the Office of the Assessor Recorder, is accessible to you. You can walk in, you can email us, you can call 311 and get referred to us if you forget our number. But we are here to help answer those initial questions and help refer you to those who can help deal with the very specific issues you may be facing regarding your property and your assets. How does that sound?
Great.
Okay, all right. So here's what we'll do today. We'll talk about property assessment basics. We'll talk about the intergenerational impacts of Proposition 19 very specifically, and then just some key dates and point of contact, like what I just mentioned earlier. And then if we have some time, we'll be able to take some questions. Just as a disclaimer, none of this is meant to be guidance or advice. None of this is meant to be guidance or advice. Again, everyone's individual situation is unique and particular. Just to give you a sense of this, sometimes when you think you've completed a document out correctly, even ink in the wrong area or the wrong box can invalidate a document. So just thinking about those particulars, you want to be sure that you are working with professional advisors after you have a general understanding of the work in front of you to ensure that everything is being taken care of for your specific situation. All right, so is everyone here familiar with Proposition 13? Okay, so I have some yeses and I have some nos. Essentially, Proposition 13 is a constitutional amendment that was passed back in 1978 when Jerry Brown was governor the first time for the state of California. And essentially what it does, it provides a cap on how your assessed value, which determines what your tax obligations will be, it caps what your assessed value is allowed, the rate at which it's allowed to grow. So you buy a property for, say, $1 million today, or in the past, maybe $150,000. And each year after that, the value of that property per Proposition 13 is only allowed to grow by 2%, no more than 2% per year. Quite typically, the CPI is above 2%, and Proposition 13 ensures that the value of your assessed value of your property will never grow by more than 2% each year. During the pandemic, there was 1 year in which CPI was less than 2%, and that was the 1 year when you may have seen your property tax assessed value be lower than 2% growth than the previous year. What you can see here is a basic example of how this protects and lowers your property tax obligation year over year as compared to what the market rate value of your property is. Again, assessed value is separate and apart from market value. The market value that you see here is delineated by the red line, and the assessed value delineated by the blue line. You can see here the huge delta between an assessed value of $196 and $196,000 in 2024 as compared to the actual market value of that property in the same year of $1.2 million. The home was purchased back in 1990 in this example for $100,000. And even though the market value is $1.2 million, the assessed value upon which your property tax obligation is based has only increased by $96,000 over that 34-year period of time. As I was mentioning, the only change that's occurred to Proposition 13 happened very recently in November of 2020. Does anyone remember what the sky looked like around the time that your ballots dropped in 2020? Exactly. And so the element here that caught most of our eyes, and one of the reasons it caught most of our eyes, is because it was what you saw on the ballot. It was about how to take a base year value transfer for seniors ages 55 years of age and older, those with disabilities, and those who have been impacted by a natural disaster, whose smoke we were breathing at the exact same time these ballots were dropping at our addresses. The second component, which was not as clearly articulated, I would argue somewhat subsumed in the ballot argument, was the intergenerational transfer exclusion. And just a bit of editorial comment here. The reason that I state that is because quite often when I talk to people about this provision, they feel like they were hoodwinked about this, and they felt that, am I crazy? Did I miss something here? No, the answer is you did not miss anything. You did not, it's not your fault that you missed anything here. We all assumed that the goodwill of those who wrote the ballot were focused on the base year value transfer for wildfires and for seniors who have been impacted there and the benefits therein. But buried in the language, deep inside the ballot argument, you had this additional information that impacted people that's been very controversial as people become more and more aware of how this affects them. And I'll go into a little bit of that shortly. There was a huge rush, as you can see. The ballot measure passed in November of 2020 at the ballot, with a little over 50% of the vote in California. That became active in February 16th of the following year. So just a few short months after that. A huge rush of activity in the middle of a pandemic to ensure that people could take advantage of the old rules before the new rules kicked in regarding number 2 here. And then, of course, as I mentioned, the base year value transfer. That one did not become active until April of 2021, 2 months after the other provision did. So what is the intergenerational transfer? It is when a family home was excluded from reassessment. What is reassessment? That would be an example of when a home would change hands, the value of that home for tax purposes, the assessed value, would have jumped from earlier, you saw the blue line, up to the market rate value of that property. So what the intergenerational transfer language proposes is that you're excluded from reassessment to market value when the home is transferred between a parent or a child, or a grandparent and a grandchild. The catch is that only the family home qualifies, which means that it has to be the person's principal place of residence, where you live, where you vote, where you come home from work, or where you used to come home from work. The child or the parent must live in that property and make it their primary residence within 1 year of the transfer of that property or the death of the person who is handing the property over. All other real property, second homes, apartment, other real estate investments, those do not qualify, and all of those are now reassessed up to market rate value. The amount of the exclusion has a cap to it. It's capped at $1 million plus that factored base year value, and I'll get into some more details about that in a moment. So again, the qualifications: principal place of residence, where you live, where you come home from work, the address that's listed on where you vote, your utility bills, etc. The transfer prior to the date, it has to be where you were living when you made that transfer. The transferee, the beneficiary, has to move into that home within 1 year of the date of that transfer. And there's also all of these obligations. You have to file for an exemption within 1 year, and you must continually use that home as your family home to maintain the lower value. To help you determine your principal place of residence, I've gone over that, I think, pretty succinctly here. But again, just remembering, you want to go over the rules. It's pretty straightforward. Where you live, where you work, that's your principal place of residence, and also where your current homeowner's exemption is applied. If you are a homeowner and you have not taken advantage of the homeowner's exemption, it essentially is a very small dollar cash value of around $79 in actual cash that you are not spending on property taxes. The assessed value exemption reduction is around $7,000 in assessed value. Again, you're eligible for that exemption, and you need to file this form here. And again, there are checklists that our office can provide to you when you are pursuing this path. With regards to a multi-unit dwelling, so as I was saying before, it's a principal place of residence. Well, oh great, I have a 4-unit apartment building, and I live in that 4-unit apartment building. So great, I can transfer that property from me to my child or to my grandchild if that rule applies. Well, no, not exactly. Only the unit that you are in is able to be qualified for that reduced assessed value. All the other units would then be adjusted up to market rate value. Oh, well, okay, well, maybe I can move from the ground apartment, and then when I give the property to them, they can move into the upper apartment on the 4th floor, the window that now that we've transferred the property, they can live there. No, only the principal place of residence where you have actually been living is allowed to qualify for that transfer of the lower assessed value. So again, so many details here that it's important for people to know. And so many people who feel like they were making investments for the future feel very, very upset about how these rules changed during the time period that I talked about. Again, the filing requirements, I'm not expecting you to know all of these, and we do have these available at our office. The most important thing to remember is, when I'm considering this, what do I have to do? It's the most basic question you can ask our office. What do I have to do? And we'll provide you that information to make sure you understand exactly what filing requirements there are and within what time period you must file them. Another note that I want you to make is that if you are transferring a property for those who are about to receive it, you want to understand what the market rate value is. It's been determined by the appraiser, those who work in my office, at that period of time, because you only have 4 years, currently based on state law, how this was passed, to challenge that number. That may not become material to you or of interest to you until suddenly the beneficiary has decided that they've saved up enough money because of a lower taxes, they can buy a secondary property. Okay, I know that once I leave this original property, that value is going to rise, but then suddenly I see, wait a minute, you value that property at much more than it was worth at that period of time. Well, you needed to appeal that much earlier in the process per state law. We are just noticing that issue today because we've now exceeded 4 years since the law came into place, so we're having conversations currently with the State Board of Equalization to see what their determination is about this issue, and then also pursuing potential ideas to correct this. But again, the filing requirements, the exemption claim, the exclusion claim, the most important pieces you want to remember here are these are time limited in terms of when you must file these. If you miss the deadlines, you are responsible for that increase in value. Let me give you just another sense of what that means. So if you miss a deadline, you're not paying taxes on $196,000 a year. You're paying taxes on $1.2 million a year for that one particular year. And then you realize what's happened. The law states that that is the law. And then in the future, you can change that in future years. You will be able to, again, be a beneficiary of that lower assessed value with the corresponding rules that I talked about before. So again, it's very important to pay attention to the deadlines and the paperwork that you must be filing. So again, that's why I say, who are you working with to do this work as you're considering these pieces, making sure you have that checklist, double-checking that list. Here's an example of that in terms of a late filing. So, and again, you saw here on this previous slide, there's 2 claim forms, each with wonderfully confusing different deadlines. So again, I point this out a little bit tongue-in-cheek because I want you to know it is confusing, but this is how the law was written, and this is what we as voters voted on and allowed to pass. Here you have a parent that passes away on June 15th of 2022, and the estate plan leaves the family home to the child. Reminder, you see in the blue, this form should be filed within 1 year. And then the secondary form should be filed within 3 years. You can see here that based on the dates on the far right, that the exclusion claim was filed on time. However, the homeowner's claim was not filed within 1 year. So then, in that case, they're going to be paying taxes at that higher market rate value as opposed to the lower assessed value that the previous owner was benefiting from. And then you can file and then get that prospective relief. So again, all I want you to remember is remember the deadlines, have a list, double check it, double check it. Here are some questions we have around trust distribution that have come up in many of the conversations I've had in community, like the presentation today. My mother's trust leaves her home to me and my 2 siblings equally. Will this property be subject to reassessment as of our mother's passing? The answer here is that for the property to be excluded from reassessment under Prop 19, just pretty simple here, at least one of the children or qualified heirs must occupy the family home within that 1-year period. Both the homeowner's exemption and Proposition 19 exclusion claim, both those forms have to be filed on time to qualify for the exclusion from reassessment as of a day of death. Another question, I've heard that parents, everyone thinks there's a loophole. Everyone thinks there's a loophole you can get around. I hear there's some legal trick I can do. What if the parents set up an LLC with their children and put the house into the LLC? Well, since the ownership doesn't change on the death of the parents, the property isn't reassessed. Is that correct? Well, no. LLCs are not always an automatic avoidance of reassessment. There are other details involved here depending on the particular case. California property tax laws governing this legal entity ownership transfer, they're very complex, and you should be discussing this with a qualified estate planning attorney, another legal advisor, to ensure that you understand that anything that you're pursuing, you understand what the property tax implications could be. The last thing I want to see happen to anyone in this room when you're going through this process is you make a false assumption that has serious financial implications. One example of where a reassessment would occur despite a property being in an LLC is where there's a change in control in which one member of the family gains more than 50% of an ownership stake, triggering a 100% reassessment of that property. So again, just paying attention to those details and making sure that you are even double-checking with your attorneys that this clearly makes sense to you, what the process looks like, and any other financial implications that they have considered. Not all attorneys are created equal, and it always requires us to be diligent about this process. So again, I know it's complex. I know it can feel like a heavy burden having to go through this. Attorneys are very helpful. They're not all perfect. So again, just be mindful of this as well. And sometimes just a basic question can say, oh, we need to make sure we need to file the secondary exemption form, etc. What if a child moves out in a situation like this where there are two beneficiaries? If another eligible transferee, a sister, a brother, another non-gender conforming sibling, moves into the property within 1 year of the other moving out, and they timely file for the homeowner's exemption claim form, again, it's about to be their principal place of residence, then the exclusion continues. If no other eligible transferee moves into the property within 1 year, then the exclusion is removed, and you see that rate go back up to market rate value. The property is then reassessed as of the time of the transfer, so that date of the transfer. How do you add a family member to a deed? Here's just another reminder of what I said in the beginning. Avoid self-preparing your documents because you want to be sure that everything is completed to form. You want to consult with a title company or an attorney. You want to review the recording requirements with our office on our website and ask about any other consequences, transfer tax, or other reassessment consequences. So again, the checklist here, these are very easily available on our website, but you can always just call us up and ask, and we can also email these to you as well. Just remembering that we've been using this $1 million on top of the intergenerational transfer. So as an example, let me just go back here. So you see that the amount of the exclusion is capped at $1 million for these kinds of situations, plus the factored base year value. So in this case, you have $196,000 plus $1 million, that's 1.196. You're just under that $1.2 million amount, so you're okay. If, let's say, this was $400,000, then you add that $1 million plus $400,000, that's $1.4 million. Instead of paying taxes on on that $400,000 only, you're going to be paying taxes on the difference between 1.2 million and 1.4 million, which is $200,000, which would then get added to that $400,000. So then you're paying taxes on $600,000. Still not 1.2 million, but there are these limits to what the exclusion provides. So again, just thinking through as you're doing financial planning of having to spend that that mind-numbing time on going through the basic numbers. And the reason I wanted to just jump to that is because we use 1 million as a rough number. There have been small number adjustments here that are happening for this year and then will again happen again in 2027. And sometimes those little adjustments will matter over time depending on what your existing assessed value is for that property. Yes? Yes, ma'am. Yeah. And again, I think what's important as well is you just follow back up with our office. You can always ask for our office through 311, and you can ask about what are the forms I need to file when considering an intergenerational base year value transfer. Yes. BOE 19P. So again, if I just give you the numbers, it's pretty straightforward, isn't it? So this is why we have a checklist here, just so you can come back to this, because no one should be expected to hold all this in their heads when they're dealing with just monumental moments in their lives, like transferring property from one generation to the next, dealing with a death in the family. These are very hard conversations that we have to have. It's good to have them so we're prepared ahead of time. Base year value transfers now. This is the less controversial and more beneficial in many people's eyes. This allows homeowners to transfer their taxable assessed value or factored base year value to a replacement home when they sell a property and purchase a new property. Both the property you sell and buy, again, must be that primary residence. You can do that now, as opposed to there used to be restrictions. You can buy anywhere in California, whereas previously it was only certain counties, and you can change homes up to 3 times. There's no limit to the market value of the replacement home, but any amount over the original property's market value is added to the assessed value. So again, you'll need to do that math as well in terms of what is the value of the property. Yes? No. This is essentially, if I am a senior, 55 years of age or older, or I'm a person with disabilities, or I've been impacted by a natural disaster, I can qualify for the base year value transfer. And what that means, again, is that I'm able to say I'm impacted by the fires up north. I need to seek a new home, or I'm going to rebuild my home in that area. I want the ability to take that lower factored base year value, let's say it's that 196 number that we saw earlier, and be able to maintain that as I move to a new property. Yes? Oh, and just with regards to 1031 in your question, that's specifically regarding capital gains and not the tax issues that we're talking about here. So what I would offer is that just to keep things focused just in this area is that for the additional tax implications, you want to have secondary conversations with an estate planning or a tax advisor or a legal advisor to get answers to those questions. Again, here, there's no limit to the market value of the new property. But if the value of that property is greater than the market value of your new property, you will be once again, in a similar formula, that delta will be added to your existing base year value, added to that 196 number again, or added to that $400,000 number again. Who is eligible? Again, we talked about 55 years of age or older, severely and permanently disabled, those victims of a wildfire or natural disaster. And again, here's a time limitation as well I want you to be cognizant of. The replacement home must be purchased or newly constructed within 2 years of the sale of the original property. The homeowner must occupy that original property and replacement property again as your principal place of residence. So here's a quick example. The owner purchased a new replacement home on April 4th of 2024 for $1.5 million. The owner's original home had an assessed value of $250,000 and was sold on August 15th, 2024 for $1.2 million. The replacement home must be purchased within 2 years of the sale. Any amount over the original home's fair market value is added to the assessed value. So you can see here, as you go down in the analysis, the replacement home was purchased within that time period. The home exceeds 100% of the original home's fair market value by $300,000. That $300,000 is added to the assessed value of $250,000 for a new assessed value of $550,000. Again, you're not paying taxes on that $1.5 million, but you are paying taxes at a greater amount than the previous assessed value you were carrying. But you have the flexibility to move into a home that's worth more than the one that you have currently from a market rate value perspective, and you're able to take that lower value with you from county to county. Yes?
And what happens if my replacement home is less now?
Then you're still going to be carrying that much lower assessed value.
I can't go below my prior tax value, but if I
Correct, correct. Specifically in regards to a base year value transfer, which is a separate rule than the intergenerational value transfer here. And then just to put it into clearer context, I know it could get fuzzy, but does anyone know of a home that we can buy right now for $250,000 in California? So in that hypothetical, I'm saying that just so we're all clear on that, because I know if we just talk about it generally, it gets kind of fuzzy, for me at least. So I want to make sure you're all aware of that. So that lower assessed value, you're good there. In terms of that value, you're not going to be finding a replacement property, unfortunately, for anything lower than that. So you're going to be maintaining that value even if the value of that property is lower than the market rate value of your existing home. Again, it's much easier when you're dealing with your own real numbers, writing them down on paper, and just doing those steps. That's what helps me. Again, here's the filing checklist for you. If you want to just take a quick note of that or a quick shot of that. But again, remember, you can always reach out to us when the time is right, which I hope you do, to make sure you have the checklist and are aware of any changes to the rules that might be pursued over time. And you can see here again, it gets even clearer with a new filing deadline within 3 years of the date of a replacement dwelling is purchased or new construction of a replacement dwelling is completed to submit these forms. And if you miss that, the same rule applies. You'll be paying the larger amount based on fair market value, but you can still file for prospective relief in the future. But again, remember to pay attention to those deadlines. They have serious financial implications for you if you miss them. Many people are asking, well, are there changes being pursued here? Myself and other assessors in California have been very vocal about this, but the state legislature has not picked up wanting to pursue any changes to Proposition 19, as has been passed. The Howard Jarvis Taxpayers Association has pursued a signature gathering to try to place this both on the ballot and for a hearing with the state legislature. They have not been successful to date. As of right now, I am not hearing of any new grassroots efforts to pursue changes to Prop 19. As a reminder, you can always reach out to our office, but again, you have resources at the state level as well with the Board of Equalization and their frequently asked questions and guidance. They may also provide information around Prop 19 information and those answers to frequently asked questions that are similar but different from ours. In terms of low-cost resources, we have a Housing and Economic Rights Advocates, which is one of our main partners in estate planning. We have legal assistance to the elderly and Open Door Legal as well. Again, you can always call us up and we can provide this to you when and if you're ready to begin pursuing this process. Just a quick mention, with no taxpayer dollars involved, I created an estate plan program with philanthropic funding with Housing Economic Rights Advocates to create 200, and we will have more in the future, 200 free or low-cost estate plans that are complete in terms of one-on-one legal consulting, financial workshops, providing you with a complete estate plan. Those documents include a will, living trust, a health care directive, and a power of attorney to make sure all of that is in order for you. You saw their information. You can see their information again right here at the bottom of the slide. You can always call them, or you can always reach out to us to ask for that referral as well. Free or low cost is dependent on income. If you are low income, it is free. If you are a little bit more than that, you're paying around $400 for a $3,000 to $3,500 product, depending on what you are looking for. Sure. Let me come back here to the larger ones. 510-271-8443, and their extension is 300. And please do tell them when you speak with them that you got this information about reaching out to them through the presentation with us. Primarily, our program that philanthropic funding applies to for those free or low-cost plans is focused on the southeast part of the city. One of the reasons for that is that this basic data point that 70% of African Americans nationwide do not have an estate plan in place. So where we looked at demographics that overlaid with communities of color and also with home ownership, primarily in the southeastern part of San Francisco. With these limited resources, we are focusing our efforts there, in addition to the western addition. We're not turning anyone away, but that's where we're focusing our presentations and our outreach. As a final note, key deadlines here. Lien date, how am I valuing your property year over year? It's based on January 1st, which is what we call the lien date. The exemptions deadline, when you are seeking to file your homeowner's exemption, or nonprofits are reaching out to us, that February 15th deadline really matters to them. And then informal review. So if you believe that the value of your home is going to be more than the market rate value, this assessed value and the market rate value of your property will dip below that number, know that in January 2nd to March 31st, you should be reaching out to us to say, I believe that my market value of my home is less than my assessed value. Will you please take a look at this? Where we have been able to do this proactively with market data, we have reached out. Where people have reached out and gone through the formal appeals process, which happens every year as well, from July to September 15th, unless that date falls on a weekend, it changes, where you file a formal appeal. We are facing huge numbers of appeals at the independent separate office of the Assessment Appeals Board, and we are moving through these processes as fast as we can, but I want you to be aware of these options that are available to you. And again, there's nothing wrong with just reaching out and asking, hey, I believe this is the case, I would like you to look at this. And again, remembering for informal review, January 2nd through March 31st. We close the roll every year on June 30th. That's when we place that $354 billion worth of assessed value on the roll for the purposes of establishing what the tax obligations will be for over 211,000 parcel holders in San Francisco. And of course, again, as I was mentioning, this provides the most stable and secure source of funding for the city and county of San Francisco and all other counties up and down the state of California. Real property, you will receive in July, as you know, if you're a homeowner, a notice of assessed value. You'll notice it says, not a bill, not a bill. The bill comes from my colleague, Jose Cisneros, the treasurer and tax collector. If you have a question about the bill, you need to reach out to Jose. The reason we send out this notice is because if you want to get ahead of the question, because you know where this is going, it's heading towards that bill, and those due dates that happen twice a year, you want to reach out to us as quickly as you can. And this especially applies for those who are recently purchasing a new home in the middle of the year. They receive a supplemental, which means that we're catching up to the process of the new value of that piece of property. Always reach out to us. Always reach out to us. And if there are issues, reach out to me directly. Business personal property has different deadlines. July, the notice and the tax bill arrives around the same time, and then August, that tax bill is due. City Hall, room 190, first door on your right as you walk through the metal detectors. The sheriff cadets are very friendly. Come on in if you want to visit us in person. If you want to, we have a new code that you can scan if it's a busy day. You can get some coffee downstairs while you're waiting for your number to be called, so you aren't just sitting there like in a doctor's office waiting for hours before you get seen. These are improvements that we're making so we can serve you better. 8 a.m. to 5 p.m., sf.gov/ASR. You can always just Google Assessor's Office San Francisco. You can call this number here or make it easy for yourself, call 311. And you can always email us at assessor@sfgov.org. That's assessor@sfgov.org. So thank you very, very much. And I know if there's any other questions, please do send them our way. If you need some time to develop those questions, email them to us at assessor@sfgov.org, and we will answer those for you. Thank you very, very much. And again, always for the partnership with the San Francisco Public Library.